So the date is Friday, June 29th, on a very special TrumpCon law.
Emergency Trump
Emergency TrumpCon law. And I'm here with Elizabeth Joh. And why don't you tell me what happened 2 days ago?
So on June 27th of this week, we had special news from the Supreme Court. It wasn't totally surprising. There'd been a lot of speculation about this, but it turns out that Justice Anthony Kennedy announced his retirement from the Supreme Court. It was at the conclusion of the Supreme Court's term, which begins on the first Monday of every October and ends at the end of June. So one thing to remember is that all federal judges have what's called life tenure.
Mm-hmm.
So there's three ways to lose your job. One is you get impeached. Doesn't happen that often. One, you die. Justice Scalia, for example, died in 2016. Or you retire. And that has happened a few times, certainly. And so Kennedy chose the third option. He decided to retire at the end of the term.
He chose not to die.
He chose not to die, not just yet.
Okay.
So he is 81 years old. He's going to turn 82 next month. He was nominated by President Reagan, and he took his position on the court in 1988. So he's been on the Supreme Court for a really long time.
Why does this matter right now? Because Trump is about to pick Kennedy's successor. Let's do this. This is What Trump Can Teach Us About Con Law, an ongoing series of indefinite length where we take the tweets and the turmoil around the 45th President of the United States and use it to examine our Constitution like we never have before. Our music is from Doomtree Records. Our professor and neighbor is Elizabeth Joh. And I'm your fellow student and host, Roman Mars. Quip is a better electric toothbrush created by dentists and designers. They wanted it to be simpler and more enjoyable to brush your teeth. That's why new brush heads are shipped to you automatically every 3 months. You don't even have to think about it, and you can follow your dentist's recommendations, so you're not one of the 75% of people using bristles that are worn out and ineffective. Plus, Quip comes with a cover that slides right over your bristles for on-the-go brushing, so you can take it with you anywhere you go, and you don't have to worry about your toothbrush getting all gross along the way. I got my own Quip. It's a silver one. It's going to be great on my next trip, and I know when I'm on the road, I will brush my teeth the requisite 2 minutes because of its fancy pulses. That's why I love Quip, and why they're backed by over 20,000 dental professionals. Quip starts at just $25, and if you go to getquip.com/conlaw right now, you'll get your first refill pack free with the purchase of a Quip electric toothbrush. That's your first refill pack free at getquip.com/conlaw. Okay, so tell us, why does this matter? Why does this matter right now?
Okay, it matters right now because Justice Kennedy's absence, because of his retirement, creates a kind of special hole on the court. So remember, there are 9 justices on the Supreme Court. Right now, there are 4, you might call them liberal justices, Justices Ginsburg, Breyer, Sotomayor, and Kagan. And there are 4 conservatives, Chief Justice Roberts, Thomas, Alito, and Gorsuch. And then there's Kennedy. Mm-hmm. And remember, on the Supreme Court, it takes a minimum of 5 justices to issue a decision, a binding legal decision, at least 5. You can have more, but you need 5. So Kennedy has had this special role in the court. He's certainly a conservative a lot of the time, but sometimes he's decided to join the more liberal justices on the court in a number of different areas. So when it comes to affirmative action, the death penalty, solitary confinement, issues like that, he has decided to join the liberal justices in coming together to form an opinion. The 2 areas I think that he's been most recently well known for have been gay rights and abortion. So when it comes to gay rights, he was the majority opinion author. In other words, he wrote the opinion in a case called Lawrence versus Texas. So in Lawrence versus Texas, that was a Supreme Court case which struck down a Texas criminal law that led to the arrest of 2 men who were involved in consensual sexual activity. So after Lawrence, a state cannot criminalize sex between 2 consenting gay or lesbian couples. So he was also the author of the majority opinion in Obergefell versus Hodges. which recognized a constitutionally protected right to gay marriage. That was really a groundbreaking case to, for the first time, recognize this right. There's certainly been a constitutionally recognized right to marriage, but there hadn't until Obergefell really been a decision talking about, does that same right also protect same-sex marriage?
Mm-hmm.
And Kennedy wrote the opinion that recognized it. You know, it's interesting here. I'll quote the first line from Obergefell. Kennedy says, "The Constitution promises liberty to all within its reach, a liberty that includes certain specific rights that allow persons within a lawful realm to define and express their identity." He's also associated with the court's decision to recognize a constitutionally protected right to an abortion. So here, this is where the popular conception of abortion rights and what actually has happened in the court is a little bit different.
Mm-hmm.
So everybody talks about Roe versus Wade, decision from 1973. But actually, the reason why there is today a constitutionally protected right to an abortion, that stems from a 1992 case called Planned Parenthood versus Casey.
Mm-hmm.
And in that case, that was a decision where before the Supreme Court issued its opinion, people thought Casey would be the decision where the Supreme Court actually reversed itself and would reverse Roe versus Wade.
Uh-huh.
But in that Planned Parenthood case, Kennedy, joined by Justices O'Connor and Souter, they issued an unusual joint opinion. In other words, they spoke as one voice in recognizing, you know what, we understand this is a really divisive issue, and we know that everybody's watching this. And today we are reaffirming that there is such a constitutionally protected right to an abortion. So it's actually the Casey decision, in which Kennedy played a crucial part, that's responsible for having this constitutionally protected right today. On the other hand, you know, Kennedy is not a flaming liberal.
Right.
He is not, you know,
Right.
a card-carrying progressive. He's joined the conservative justices in a number of cases. He joined the majority in a case called Citizens United.
Right.
You might be familiar with that. That allows unlimited spending in campaigns by corporations and unions. He was in the majority in Bush versus Gore, which of course gave the 2000 presidential election essentially to George Bush. And his very last opinion on the court, right before he announced his retirement, was joining the conservative majority in upholding Trump's travel ban. So he hasn't been a flaming liberal. So why does this matter, though? So go back to this idea that you need 5 justices to make an opinion, to make law on the court. So what that means is when there have been closely divided cases where Kennedy has been that critical 5th vote, that means in some of these hotly contested issues, one justice changing his or her mind can make all the difference. It could be a radical change in the law. That has a lot to do with our American system. So in American law, we have what you might think of as a really strong form of judicial review. In other words, courts getting to review legal challenges. So for the Supreme Court, that means with matters of constitutional law, what the court decides is final and binding unless and until they change their mind.
Right.
So you could imagine a different system, and this exists in other countries, where a high court, like a Supreme Court, could issue a decision, but maybe the legislature could overturn it, or the executive could overturn it. But in the American system, what the court does is final, essentially.
Well, couldn't the legislature rewrite the laws so it would be interpreted differently, or
in matters of constitutional law, right?
Which doesn't get changed.
Doesn't get changed unless we change the Constitution,
which is nearly impossible.
Doesn't happen,
Yeah.
right? So that really places a lot of focus on the court itself and who is actually serving on the court. Okay, so what happens in terms of Kennedy's leaving the court? Well, who is going to pick his replacement?
Well, Donald Trump's going to.
Donald Trump, of course. This will be his second pick on the court. His first was Neil Gorsuch.
Mm-hmm.
But it's important to realize that this is not just, well, it's just his second pick on the court, which by itself would be an important topic. Remember that Gorsuch took the spot of Justice Scalia, who died. But essentially, Scalia was a pretty conservative justice with some exceptions. And Gorsuch really replaced that spot.
Right.
But here, in Kennedy's case, it's pretty unlikely that President Trump is going to pick someone who is going to be more or less like Kennedy. He's very likely to pick someone who is much more conservative than Kennedy. So that means that in a number of those cases or those areas of law, like abortion, gay rights, affirmative action, death penalty, that critical swing vote, as it's sometimes called, might disappear.
Right.
And in fact, it might be the case that some of those cases might be subject to being overturned. That would be the most radical change, or more likely chipped away radically, right? Narrowing the effect of those prior decisions so that the rights recognized in those decisions have sort of less power.
When the news was announced, it was treated like a bomb had gone off, and all the liberals were very, very upset. It did feel similar to when Trump got elected, because it does feel like it has a cataclysmic effect on everything hereafter.
Right. There's two reasons. One is that has to do with the structure of how we appoint justices on the court. Part of that has to do with life tenure. So why should the decision of one 81-year-old man make everyone upset in the United States or many parts of the United States? Well, that has to do with the fact that we have life tenure. I mean, why life tenure? Why not have 20-year terms or 30-year terms? But we don't have that system. So a lot depends on the decision of one particular person on the court to decide to retire. The other thing, too, of course, is that President Trump gets to pick this person with the advice and consent of the Senate. That's built into the structure of the Constitution. And we're now in a position where the Republicans control both the presidency and Congress. So it's quite likely that whoever President Trump nominates will be confirmed by the Senate, the Republican-controlled Senate. Senator Leader Mitch McConnell, of course, said, we want the president's nominee to be announced to be treated fairly. There's no small irony there. And, of course, Merrick Garland, nominated by President Obama, didn't even get a hearing before the Senate. But apparently it doesn't matter. What will happen, right? Well, the Democrats could try to sway a few members of the Senate to not vote for a particular nominee. Remember, right now, the Republicans have 51 senators on their side. If they lose one vote, that's okay, because Vice President Pence, as the leader of the Senate, would be the tiebreaker. But they can't lose two. They can't lose two votes. So there's some speculation, for example, that if Senators Collins or Murkowski are persuaded by the Democrats, maybe a nominee wouldn't be confirmed. But again, these are kind of, I don't know how likely those scenarios are.
And, historically, Supreme Court nominees get confirmed because the people brought up for confirmation are qualified to do so. And it was sort of for a while considered out of bounds to take their political leanings into account when senators were making the decision to put them on the Supreme Court.
Sure. I mean, there's this idea that, all we care about are judicial qualifications. Do they seem like the kind of person who can make well-reasoned opinions? And that's an understandable sort of cutoff point. But for a lot of these issues that we've talked about, like abortion and campaign finance, the death penalty, gay rights, again, because of Kennedy's particular role, I think people will be even more interested in whoever President Trump nominates. And he's announced that he's about to interview people, and he'll have some decision to make by July 9th.
Do you think it's fair or important to get the political biases of these potential judges out there to the public and to the senators?
I think it does matter that at least we know about them. I mean, I think it's, whether or not it's right to pick someone based on those, it's really up to the Senate, right? But the Senate represents the people. And the people do deserve to know, if they are not in favor of a nominee, they should know what those person's views are. And with that in mind, they can decide either to urge their senator to vote yes or no. So it does matter. I mean, one of the things that is funny about the judicial process is that we want the judges and justices on the Supreme Court to be apolitical. But the confirmation process is essentially a very political act. It is extremely political. And so in that sense, it's uncomfortable for lawyers to think about it that way. But the truth is we do want to know what these people think before they are appointed as a Supreme Court justice. And this is a very different kind of appointment, right? The reason why you and I have had these conversations all this time is because of President Trump. So whoever Trump picks, think about all of these open questions that we've been talking about. When does the president violate the emoluments clause, right? When does a president, if ever, obstruct justice? Is it okay for the president to pardon himself? It's very plausible that one of these questions will go up before the United States Supreme Court. What does it mean for President Trump to then handpick a key person on that court to perhaps be a decisive vote in one of those matters. And we know that he is a person who is very much interested in personal loyalty. Is it that out of bounds to think that President Trump might, in some interview, ask a potential nominee, would you be loyal to me?
Right.
It's not the way we think about the presidency and Supreme Court nominees, but this, again, has been a very unusual presidency. And if that's the case, that makes it all the more urgent that we know something about what this nominee's views are.
If you were a senator in the confirmation committee, would you ask questions specifically related to Trump?
Sure.
Yeah.
I mean, I think the problem is, what kind of answer do we want? I mean, what kind of answer would be a satisfying answer? Or, and I think the convention now is that nominees are coached to say very little.
Right.
They would say something like, well, I haven't considered that matter,
Right.
so I don't know.
You'd have to come up in front of me as an actual case.
Pretty implausible, but that's what they'll say.
Yeah.
Right. But that's what's at stake. It's not just the stability of the cases that the Supreme Court's already decided. It's all of these great unknowns that Trump himself has brought up. And imagine that the Supreme Court in some, next term, for example, has to decide, can the president pardon himself? It comes up somehow.
Mm-hmm.
Well, it's not going to be a unanimous court. I highly doubt that. It's going to be a split court. And if it's close to a 5-4 decision, 5 justices on one side and 4 on the other, it's who is going to be that swing vote. That's what's going to matter in this kind of case.
Is there anything in the structure of the court, or the Roberts Court in particular, that is a check on this just being an incredibly conservative court that makes incredibly conservative decisions?
Well, there is some sense that the court itself as an institution wants always to at least have the appearance of being insulated from day-to-day politics.
Mm-hmm.
I think the Chief Justice, like his predecessors, is likely to want to make sure that the body itself remains as an institution that people think of as legitimate. It's not going to be seen as legitimate if the decisions seem purely political.
Right.
So sometimes that's enough to put enough pressure on at least some number of justices to say, I don't like these prior cases, but boy, we can't just, stick our finger in the wind and decide we're going to overturn that case. The Supreme Court doesn't overturn its own decisions lightly. I mean, it makes a big show of when it does so, saying we really made a huge mistake here. Would it be willing to do so in a variety of ways? I don't know, but it's certainly a risk now that President Trump is going to nominate someone who is very likely going to be much more conservative than Justice Kennedy was.
Right. So it wouldn't be like we're overturning Casey. It would be like we're going to allow states to put like you have to go to counseling and you have to have 3 days of waiting and all that sort of stuff. That would be the way you would chip away at these rights.
Right. And that's already been happening in a lot of subsequent cases to Casey. But you could see even more of that.
Mm-hmm.
And, again, you say, well, we wouldn't overturn Roe, or the court wouldn't overturn Roe and Casey. Well, I'm not so sure that's that clear, right? I mean, again, abortion and gay rights are really controversial issues. And, we will have to talk about this in another show, I think, but they both address parts of the Constitution called substantive due process. And that area of the law really refers to the Supreme Court deciding that there are certain unwritten rights that we have based on the Constitution. So unlike the Second Amendment, we can all disagree what the Second Amendment means, but there's no question that it refers to arms, right?
Right.
But there's no word abortion or
Right.
marriage in the Constitution.
Absolutely.
So those are even more particularly controversial.
Right.
And the kinds of areas where conservative judges and justices have been highly critical of these decisions.
Mm-hmm.
So I think particularly vulnerable to chipping away at those rights or even possibly overturning them. So it doesn't happen overnight. But then again, President Trump said at a rally on Wednesday, after Kennedy announced his retirement, I want to make sure we pick someone who's going to be there for the next 40, 45 years. And 40 to 45 years is plenty of time to make a lot of changes in the law.
Wow. If you were to change one thing about the structure of the Supreme Court, what would you change?
I used to feel that it was silly to talk about abolishing life tenure, but it seems to me like maybe that's a good thing, that maybe in a democratic country like ours, we don't want one 80-year-old man's retirement to throw us into turmoil about what the future of particular rights might be.
Right.
If every president got a chance to pick one or two justices, maybe that would be a better system.
Yeah.
So I think that's, certainly one idea to kick around.
Mhm.
I mean, should it really be this way that we have spent nothing but, the past couple of days, thinking about, wow, what does this Kennedy retirement mean? Could it be the end of abortion rights? Could it be chipping away at gay rights? Could it mean, no more progress on affirmative action or things like that? Well, maybe that's not a good thing, that all of it hinges on the retirement decision of one person.
Right. Or that the next person that is chosen will
Mhm.
be the most powerful person in the United States.
Maybe.
I mean, really.
That's right. And, one of the things that is interesting here is, this has been a whole, series of conversations about President Trump. And the truth is that even if he makes it, let's say, through the end of his second term, it's still a finite amount of time, and it's a relatively short period of time. But Trump's legacy is much larger than that. He will have appointed at least 2, if not more eventually, Supreme Court justices. Under his administration, he has appointed a large number of appellate justices. They too have life tenure, and they will issue decisions that have far-reaching consequences. Because if you think about it, not that many cases get to the Supreme Court. It's far more likely that a federal appellate judge will have more influence over more areas of the law than the Supreme Court.
Mm-hmm.
So his legacy is, you might think, well, he can't make these deals. Well, deals do matter, but the shadow of the law here is really, really long, certainly for as long as our professional lives are going to go, just to cheer you up.
Oh, my goodness.
And also, there's another thing to think about. That is, why 9? Why 9 justices?
Well, yeah. Well, that's this thing that came up with Roosevelt, where he was trying to pack the court to do things.
Now, that's not something I'm advocating. I'm not saying we should have 20 judges or 30 judges or anything like that.
Why not?
There's a difference between the court and Congress. Right?
Yeah.
So.
Lifelong tenure seems basically un-American. It seems contrary to like how we think of ourselves, to me personally.
Well, I understand what you're saying. I mean, we'd have to think about some, alternative that seems obviously better. So if you think about state court judges who run for election every time and they have relatively short terms, well, that doesn't always lead to good results either.
Well, I mean, I get why you don't want to have popular elections of judges.
Mm-hmm.
I think it's pretty ridiculous. But what is the basis for having lifelong tenure in the Supreme Court at all?
Well, I think the idea is that over time, the judges kind of gain, a considerable amount of expertise, much more so than they had previously, because these are usually people who have been judges before, about how the law should change, how the law should stay the same, what areas of the law need sort of changing or more decision making. And that comes with a long time on the bench. I think the key thing here is that, we can have a stable legal culture without life tenure, possibly, if that's one of the ideas that we can throw out. That doesn't depend. I mean, so much depended on Justice Kennedy's whim, right?
Right.
He decided today was going to be the day, or last Wednesday was going to be the day. And we're sort of in this mode of chaos right now, right?
Right.
So why should it be up to him? Why couldn't it be a kind of, thought out decision that your 20-year term is coming up or whatever it might be?
Mm-hmm.
And then we could all expect it and know what would happen next.
And could make political decisions and votes based on that.
Exactly. And I think that the key thing here is no matter who it is that ends up replacing Justice Kennedy, understand that this will be a kind of signal for a number of interest groups to aggressively pursue litigation.
Right.
That will be kind of like the bat signal for people to stay, this is our chance to try and overturn this case and that case and that case.
Totally.
That's really the main thing here. It's not simply the change in the composition of the court. You're going to see a lot of aggressive litigation.
Right.
Yeah.
Just like when Kennedy hinted that there might be a basis for political gerrymandering to be unconstitutional, caused a bunch of people to look for the right evidence to convince him, and they did not.
Mm-hmm. I mean, because he was a swing vote, some of these briefs were like sort of direct personal letters to Justice Kennedy.
Right.
Right.
This show is produced by Elizabeth Joe and me, Roman Mars. You can find us online at TrumpConLaw.com, on Facebook and Twitter. While music in TrumpCon Law is provided by Doomtree Records, the Midwest hip-hop collective. You can find out all about Doomtree Records, get merch, and learn about current tours at doomtree.net. We are a proud member of Radiotopia from PRX. We are supported by listeners just like you.
Radiotopia from